Up and running and allowing members to get settled. Will the secretary please call the roll?
And please indicate if you're in the room or on campus or in the district. Senator Rocky Adams.
I am in my office here in Frankfurt.
Thank you. Senator Kerr.
Senator Kerr.
Is she on there?
We know you're here, Senator Kerr. We'll wait on you to unmute your mic. Maybe not.
Feel free to. We do see you.
I am here. I'm here. I'm here. Can you hear me?
We can hear you now.
Okay, I'm here in my annex office.
Thank you.
Thank you. Senator Yates. And he was online at one time. Representative Bridges.
Here in the room.
Thank you. Representative Frazier.
Present in the room.
Thank you. Representative Hale.
I am present here in the room, and Mr. Chairman, I'm glad to be back with you today. It's a privilege to be back.
We are glad you're here. You look great.
Thank you.
Representative Marzian. Thank you. And Senator West.
Here in the room.
Thank you. We have a quorum.
Great. Before we get started, I'd just like to make an announcement. I appreciate all the members coming in today, because we're getting to that part of the session where this is about the only time we could fit in to do this meeting with all the other committee meetings going on. I just want to say I really appreciate it. Appreciate that we have good attendance. Also want to reiterate that we are so happy that Representative Hale is here with us, Co-Chair Hale, and glad that you are physically back and at it. And do we have any other announcements before we start the meeting that we need to do? Okay. Seeing none, first matter is I would ask for approval of the minutes. I have a motion. We have a second. Are there any additions or corrections to the minutes? Probably should have done that first. Seeing none, without objection, it is so ordered. I'm not going to make these announcements. Everyone's been told 1,000 times about how to proper etiquette on a Zoom call. So we're going to go to the first set of regulations. Please call the first reg.
Under Boards and Commissions, Board of Pharmacy, 201 KAR 2410 Emergency. This does not have additional amendments.
201 KAR 2410 Emergency Only establishes requirements for COVID-19 vaccinations by pharmacists in order to comply with federal standards. This emergency administrative regulation also makes references to routine childhood vaccinations as federally mandated. Committee amendments were approved by the Joint House and Senate Standing Committee meeting on Health and Welfare February 22nd to delete the provision that pharmacy technicians must be certified, to revise immunization training requirements to broaden the pool of vaccinators, to clarify that pharmacy interns and technicians may administer vaccinations under the general supervision of a pharmacist, and to make conforming amendment.
Thank you. I believe we have two on video to speak in favor, represent the board. Are you there? We have Eden Davis and Larry Hadley.
Yes, Larry Hadley, Executive Director, Board of Pharmacy.
Okay. Are you alone?
And Eden Davis, General Counsel for the Board of Pharmacy.
There we go. Thank you.
You're welcome.
Do we have any questions before they start? I'll give them the opportunity to present. If you don't mind, I think if you could present to us what actually occurred with this reg. This this will actually be instructive to the committee. If you could just describe to us the process behind it and what it does. What the reg does, but also the process that you went through to get it to this point.
Mr. Hadley, would you like me to speak to that?
Please, I will defer to General Counsel Davis. She has done the bulk of the work on this regulation, and she is our resident expert on this subject.
So for a brief summary of this regulation, it is an emergency regulation that promulgated in November, and we were forced to promulgate it because Health and Human Services issued a federal emergency regulation that stated that pharmacists must be authorized to administer and to prescribe both the COVID-19 vaccine as well as routine childhood vaccinations for children 3 through 18. And because our current state law at the time did not allow for such, we needed to pass an emergency regulation to be able to authorize our pharmacists to do that. What the HHS regulation also did is it allowed for interns to be able to also administer the vaccination under certain parameters. Later in December, HHS passed another declaration under the PrEP Act, which amended their regulation, which also at that point authorized technicians to be able to administer both COVID-19 vaccinations as well as routine childhood vaccinations. And so after our initial emergency regulation was filed in November, we needed to amend it yet again because of a change in federal law. And so we utilized a process that was created under Senate Bill 2 to be able to amend an emergency regulation without having to pull it and refile it. And that worked. And we had a joint meeting of both the House and the Senate committees, and they approved that amendment.
Thank you so much. Thank you for the update. I think this is the first official regulation that has been amended under the SB2 process. I think it's a very good process. I'm a little bit biased, but thank you for that report. We really appreciate that. Do we have any other questions from members of the committee? Seeing none, please call the next regulation. Thank you.
Thank you.
Board of Physical Therapy, 201 KAR 22170. This does not have additional amendments.
201 KR 22170 amends to update rules and bylaws of the Physical Therapy Compact Commission.
Do we have General Counsel Pointer?
Good morning, Keith Pointer for the Board of Physical Therapy. How are you?
Thank you, sir. You have identified yourselves for the record. Do you have any thing to present on this regulation?
Just that this regulation is simply a housekeeping regulation to change some dates and a couple of different amendments that were incorporated by reference, but it was very minor and nothing very substantive at all with respect to the regulation. We didn't hear any comments.
Okay. Any questions from members of the committee? Seeing none, please call the next regulation. Thank you, sir.
Thank you.
Board of Social Work, 201 KAR 23070 with amendment.
201 KR 2370 amends to update terminology, authorize telehealth, increase supervisor training course to 6 hours, reduce supervision hours from 200 to 150 hours over the 2-year supervised practice, add self-evaluation of supervision process, requires supervisee to complete a 1-hour training course and be an employee who receives regular wages, require a party terminating a contract to provide at least 30 days written notice, authorize electronic supervision to occur after 10 hours of face-to-face supervision, add section for applicants from another jurisdiction, and update the supervision contract. The amended after comments version changes requirements for potential supervisors of being engaged in the practice of clinical social work to a 2-year minimum, including allowing them to have practiced in another jurisdiction pursuant to Section 9 of the regulation. Requires supervisors to complete an initial supervisory training course no later than January 1 of 2022. Requires supervisors to submit a request to provide supervision form and a copy of the initial training course certificate. Deletes words self and punctuality from evaluation procedures. Deletes requirement to be receiving regular wages as a supervisee. Allows virtual supervision if the supervisor and supervisee can see each other face to face. Adds requests to provide supervision form for licensed clinical social workers from another jurisdiction requesting approval, and including the requirement to be in good standing. Requires the existing contract to be board approved and updates the contract to make various changes. The agency amendment amends sections 4 and 12 to clarify that the training and refresher courses are board approved. The staff suggested amendment amends various sections to comply with KRS Chapter 13A, including to update material incorporated by reference.
Thank you. We have some people here on behalf of the Board of Social Work. You would identify yourself for the record.
Sure, I'm Dr. Jay Miller. I'm chair of the Board of Social Work. I'm joined by Nicole Burst, General Counsel for the Board of Social Work.
Thank you so much. We do have a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. We have a second. Without objection is so ordered. We also have an agency amendment. Is there any discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment?
So moved.
Have a motion and a second. Without objection, it is so ordered. So we have before us the regs with the staff amendment and the agency amendment. This is a lot of regs. This is a long list. I will make note for members of the committee that according to staff, a large portion of these regs were added after comment. So the agency did take comments into consideration when they drafted these regs. We have any questions for members? Co-Chair Hale.
Thank you, Mr. Chairman, and I'll just direct this. It's just for my clarification to anyone that wants to answer this. As I'm reading down through this, what was actually the rationale for reducing the supervision hours from 200 to 150?
Well, the rationale was really twofold. Number one, in the state of Kentucky, we were unusually high in terms of number of required clinical supervision hours. There were no connections or correlations related to those hours in terms of quality of clinical services. So we wanted to put ourselves more in line with other states as it relates to the number of clinical supervision hours required to set for the LCSW exam. And then number two, just in terms of streamlining and more efficiently moving individuals from supervision status into independent practice status, we wanted to ensure that our supervisees had a clear and streamlined path to do that in a way that would address some of the clinical social work shortages around the state.
Okay, and then on section 6 of that, just right down from that, again, maybe I don't understand this fully, but could you just explain to me what that actually means when it says add a self-evaluation of the supervision process? What does that actually mean, sir?
Yes, so we wanted to take a twofold approach. I mean, there's one thing to talk about the number of supervision hours. It's quite a different thing to talk about the quality of supervision hours. So in order to most adeptly ensure that our supervisees were receiving quality supervision, we added a provision that would require the supervisor and supervisee to have an assessment or an evaluation of the supervision process. So it allows us to ensure that not only are our supervisees receiving a designated number of hours, but that those are indeed quality hours that will contribute to good clinical practice.
Okay, thank you very much. I appreciate that response. Very, very well said. Thank you, Mr. Chairman.
You're very welcome.
Any other questions for members? Seeing none, please call the next regulation. Thank you.
Kentucky Real Estate Appraisers Board, 201 KAR 30040 and 190-040 has a staff suggested amendment.
201 KR 3040 amends to modify standards for determining associate appraiser competency and update material incorporated by reference. The staff amendment amends Section 5 to comply with KRS Chapter 13A. 201 KAR 3190 amends to allow a licensed residential real property appraiser for a federally related transaction to appraise complex 1 to 4 residential units with a transaction value of less than $400,000 that was increased from the prior threshold of $250,000 for consistency with federal law and the national standard.
Thank you. Would you please identify yourself for the record?
Yes, John Hardesty, General Counsel for the Kentucky Real Estate Authority.
Hello, my name is Tom Veit. I'm the Executive Assistant for the Real Estate Appraisers Board.
Thank you. We have a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. Do we have a motion and a second? Without objection, it is so ordered. It appears to me that this is just a simple change to comply with new federal guidelines as they relate to the amount that is covered by an appraiser. Do we have any questions? Representative Frazier.
Thank you, gentlemen. And just for the good for the group, I'm actually carrying a bill this session for the Kentucky Real Estate Board. They're located in my district. And so I just wanted to clarify, is there going to be any additional amendments that are going to be needed? Is anything conflicting with the current legislation that's going through the process? And is this different, or was this an omission or not necessary in the other language?
Thank you, Representative. No, I don't think this will affect or have any bearing on the legislation that's currently working its way through the legislature. These are just amendments that had been contemplated, I believe, in 2019 originally, and we finally finalized them and got them filed. There's only one other anticipated amendment that will probably be affected by that legislation, but that's for another section of the appraisal board regulations. That was originally filed. We withdrew that because of the legislation that's currently working its way through. And then fingers crossed, once that makes it through, we will then refile that other reg. But as for these two, they don't, there's no bearing or no relation between the legislation and these amendments.
Okay, thank you very much.
Thank you.
Any other questions from members? Seeing none, please call the next regulation.
Board of Licensed Diabetes Educators, 201 KAR 45-130. This does not have additional amendments.
201 KR 45-130 amends to expand the length of time the board may audit continuing education completed by licensees and permit holders.
Would you please identify yourself for the record?
This is Leah Boggs. I'm the board attorney for the Board of Diabetes Educators.
Okay. Are you alone?
Yes.
Okay. We have no amendments on this regulation. Do we have any questions from members of the committee? You got off easy today.
Thank you very much. I appreciate it.
You're welcome. Please call the next regulation.
Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife Resources, 301 KAR 221, an emergency with a staff suggested amendment.
This regulation amends the daily bag limit for scaup to 1 scaup daily during the first 15 days of the regular duck season. then a bag limit of 2 SCOP daily during the remaining 45 days. The staff suggested amendment amends various sections to correct statutory citations and comply with the formatting requirements of KRS Chapter 13A.
Good morning. Would you please identify yourself for the record? If you would, turn your microphone on there real quick.
Good morning. Sorry about that. Brian Clark, Deputy Commissioner, Fish and Wildlife.
Stephen Fields, Staff Attorney for Fish and Wildlife.
Chris Garland, Wildlife Division Director for Fish and Wildlife.
Thank you. We have a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second. Without objection, is so ordered. I'll start us out with the questioning. Good to see Fish and Wildlife back. I think we missed you guys. They weren't here 1 month, were they? It's like a first in several years? 2 months in a row? Wow. Well, welcome back. The first main question that I have, and I'm a farmer and a hunter, and I have no earthly idea what a SCOP is. Could someone explain what that is?
I'll let our wildlife director do that. I could touch on it.
It's also called a bluebill. It's a diving duck, more associated with deeper waters.
It's called a what?
A bluebill.
A bluegill?
A bluebill.
Oh, blue. Okay, gotcha.
Sorry.
These masks, I can't hear. I'm sorry.
Yeah.
So we got that question out of the way. I know Representative Hale knew the answer as a former Fish and Wildlife official.
I actually did know the answer to that.
Yeah.
I did know what that was. I don't know if that makes me, I don't know what that makes me because I did know that. But I did know that. But it's we did miss you, Fish and Wildlife. We need you to come back. We need to add some spice sometimes to our meeting, and Fish and Wildlife can do that for us.
That's right. That's right.
But thank you all for being here. I don't have no comments or questions.
No, well, that's great.
Just
That's
glad
great.
to see Fish and Wildlife back, and I did know what a SCOP was.
Congratulations. We have any other questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Department of Agriculture, 302 KAR 4010 and 22150. Both of these have staff suggested amendments.
4010 establishes requirements for renewable chemicals, creation of jobs, or investment of new capital related to renewable chemical production, and reporting requirements for eligible companies. 22150 amends to establish training requirements to participate in the chronic wasting disease program, protocols for returning escape cervids, training requirements for sample collection, and requirements for reindeer exhibitions. The staff suggested amendment amends various sections to add citations to comply with the drafting requirements of KRS Chapter 13A and to add one statutory citation to the department's fee authority.
Thank you. Would the representatives of the department state your name for the record?
Mr. Chair, this is Clint Quarles, counsel for the department, and I'm very happy to have our brand new state veterinarian who is going to introduce herself next.
Morning. I'm Dr. Katie Flynn. I'm the state veterinarian for the Kentucky Department of Agriculture.
Welcome, Mrs. Flynn. Welcome to the committee. Any questions from members of the committee? Nope. Sorry, Representative Frazier, I didn't see you.
I have a few surveyed questions. I didn't
Sure.
know if we were, I know
The
chemical
committee,
one was
the
listed
committee is
first.
running on time.
Okay. All right. Great. Thank you very much. So I wanted to ask a few clarification questions in regards to the CWD and cervids. The first one would be in the situation where a cervid were to escape a pen and then is put back in the pen. Is there any type of quarantine that takes place or anything to, we don't know where that cervid had been, what it came in contact with during the time that it was out of the pen. And so I just wanted to get some clarification around that.
Dr. Flynn, if you'd like me to start, when we've amended this to make clear that an escaped cervid under, there's a couple situations, but a time period and then by direct authorization of our state vet, Dr. Flynn, they are allowed to return into the enclosure. The regs have changed substantially from a couple of years ago in that from a CWD protection standpoint, everything in the two different programs that we have when they die are now tested for chronic wasting disease. So we do have that protection. The cervids themselves are very much unlike cattle, sheep, horses, pigs, in that they require a movement permit or permission from Dr. Flynn to move to any other facility that qualifies for them to be eligible to go into. So they are in effect quarantined all the time anyway. Dr. Flynn, do you want to add?
Yeah, I think the key point here is these are certified herds that have surveillance done. Any animal that dies in these herds or is harvested in some of these herds are tested for CWD. So there is routine surveillance, and there's management practices that the producers follow within their herds for biosecurity for other diseases as well.
And I have one additional question in regards to the haulers. Is Indiana still the only state where we are receiving cervids?
Indiana is the majority of where we do receive our cervids from. However, states that have meet our requirements can apply to have their cervids enter our state. They go through a certification program in their state, and we make sure that they meet our requirements, meaning they don't have any CWD ever detected in domestic farm cervids or in the wildlife. And then, so they must not have any detections from that state. They must be a USDA certified approved state for the CWD program. And the herds from which they come from must be a certified herd. And we look at the testing records, and we have conversations with the state veterinarian to verify the testing records of the herds of origin and the certification of the herds of origin in that other state.
One last question.
Sure.
So in regards to the haulers, I understand that they may go from state to state and, pick up, drop off, that type of thing. Is there any type of log that that they keep in order to keep track of that for cross-contamination? So if there were, when you open the trailer, if there was a cervid that had passed, or co-mixing of picking up in states where we know CWD exists, is there just any type of log process?
Cervids entering the state of Kentucky must come under seal. So there is no adding of additional animals. They have to have a permit to enter, so we know when they're entering. They have a certificate of veterinary inspection filled out in advance of that. A permit is issued. Our inspectors meet the trucks or trailers entering the premises and undo those seals, inspect the animals. So the animals are sealed. There is no additions or removals in process.
Okay, thank you very much.
Any other questions from members? Committee will stand at ease. Before we move further, we do have some staff amendments. Is there a motion for approval of staff amendments? We have a motion. We have a second. Without objection is so ordered. Now we are ready. Any other questions from members of the committee? Seeing none, please call the next regulation. Thank you.
Energy and Environment Cabinet, Department for Environmental Protection, 401 KAR 60005 and 63002, both with staff suggested amendments.
401, 60005, and 63002 update federal standards of performance for new stationary sources and national emission standards for hazardous pollutants. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Would the members of the cabinet please identify themselves for the record?
Good morning. My name's Melissa Duff. I'm the director for the Division for Air Quality.
Good morning. I have one question. Does this at all change the existing air quality standards?
No, it does not. It is just adopting the federal standards into Kentucky's regulations. Sources are already subject to these as federal laws.
Thank you. We have staff amendments. Do we have a motion for approval of the staff amendments? We have a motion and a second. Without objection, it is so ordered. Do we have any other questions from members of the committee regarding this set of regs? Seeing none, please call the next set of regulations. Thank you.
Thank you.
Justice and Public Safety Cabinet, Department of Corrections, 501 KAR 6080, an emergency. This does not have additional amendments.
This regulation amends the classification manual to create separate classification forms for males and females because some factors impacted them differently. It also revises or replaces risk factors that were not validated as accurate predictors of future behavior.
Would the Department of Corrections members identify themselves for the record?
Good morning. My name is Amy Barker. I'm Assistant General Counsel here for the Department of Corrections.
I'm Karen Fain, and I'm the Director of Population Management for the Department of Corrections.
Thank you. We have no amendments. Are there any questions from members of the committee? One moment here. I have one question. This is an E-reg. So what would be the basis of the emergency as an E-reg?
The classification manual impacts public safety because it considers escape history and it considers what level of security facility to place in. So that was the reasoning for that.
So in other words, we need to get this done as quickly as possible for the safety of the inmates.
And the public as well. And we had a new prison coming online, so it was kind of fortuitous as well for that.
Okay. Any other questions for members? Seeing none, please call the next regulation. Thank you.
Transportation Cabinet, Department of Vehicle Regulation, 601 KAR 113 and 601 KAR 23030, both with staff suggested amendments.
601-113 is being amended to revise safety training course requirements for transportation network company drivers. Require that a driver complete a driver safety training course approved by the department that shall be valid for a period of 5 years and update forms in conformity with authorizing statutes. 601-23030 establishes the requirements for the administration and implementation of the speed title process. The staff suggested amendments to these regulations amends various sections to correct statutory citations, comply with the drafting requirements of KRS Chapter 13A, and make technical changes.
Thank you. I'm going to handle this set of regs a little bit different. We have staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. As usual, Representative Marzi and Representative Frazier doing yeoman's work over there today. Really appreciate that. Without objection, those are so ordered. Reason I went a little bit different this time is this must be a really important set of transportation regs because we have 8 people online to speak in favor from the cabinet. So I don't know if everyone wants to identify themselves for record. If you could just choose 1 or 2 people to speak on behalf of the regs, whatever works best for you. Please proceed. Do we have any member of the Transportation Cabinet?
John, you're
I'm
muted.
Larissa Fletcher for the Transportation Cabinet, and my colleague John Johnson is unmuting himself currently.
Gotcha.
Yes, Mr. Chairman. I'm here, John Johnson, Assistant General Counsel, Transportation Cabinet.
Thank you so much. I've just got one question. I'm a real estate attorney, and so my ears perked up a little bit with the speed title. Could you speak to that just a second? What's going on there with speed title? Is there a change to that process?
Good morning. This is Godwin Onojo, and I'm the Director for the Division of Motor Vehicle Licensing. Can you hear me, sir?
Yes, sir.
Thanks for having me. The speed title amendment is really to create an exception to the 48-hour requirement. Under the KRS 186A 170, once a speed title is applied, we are required to produce and mail that certificate of title within 48 hours. However, there have been some situations where the application were sent to us late on Friday, and in some other instances, Monday and Tuesdays are public holidays, and we receive the applications on Friday. So it will be extremely difficult for us to comply with that 48 hours requirement.
So you change it to what time period?
It's still 48, but we're just saying the exception is if we receive one that is going to be more than 48 hours because of weekends or because of holidays, that we will make sure we produce the certificate of title and mail it the next day when we come back to the office.
Thank you. Sounds simple enough. Do we have any other questions from members on this set of regs? Seeing none, please call the next regulation. Thank you so much.
Thank you.
Education and Workforce Development Cabinet, Department of Education, 702 KAR 5080 and 704 KAR 8110, both with staff suggested amendments.
702-5080 is being amended to correct and clarify language pertaining to the termination of a bus driver found to be under the influence while on duty. The staff suggested amendment amends various sections to comply with the drafting and formatting requirements of KRS Chapter 13A and make technical changes. 704-8110 establishes the minimum world language content standards for use in Kentucky's common schools. The staff suggested amendment amends the statutory authority paragraph to add a statutory citation.
Would you please identify yourself for the record?
Good morning, Todd Allen, General Counsel for the Department of Education and State Board of Education.
Any other people wish to introduce themselves? Seeing none, we have staff amendments. Is there a motion for approval of the staff amendments? There is a motion and a second. Without objection, is so ordered. I don't have any questions on this set of Representative Marzian.
Thank you, Mr. Chair. I just have a question. What are the world language content standards? What's that mean? I don't.
Yeah, thank you for the question, Representative Marzian. I have on the line with me Mickey Ray, who's in our Office of Teaching and Learning, and she can speak specifically to your question.
Thank you.
Good morning, everyone. Thank you for the question. So these standards should guide the minimum requirements that are established for a course or program for K through 12 education around world languages.
Thank you.
Any other questions from members? Seeing none, please call the next regulation. Thank you.
Labor Cabinet, Department of Workplace Standards, 803 KAR 2010 with staff suggested amendment, and 803 KAR 25300 under Department of Workers Claims. This also has a staff suggested amendment.
803-2010 is being amended to remove unnecessary language, comply with the formatting and drafting requirements of KRS Chapter 13A, and make technical changes. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes. 803-25300 establishes the procedures for a program to mediate disputes regarding the entitlement to workers' compensation benefits. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would the members, just as a note to the committee, we're actually working with two regs right here under Labor Cabinet at the same time. So we're working on the OSHA workplace standards and the workers' claims regs at the same time. We're multitasking. So would the people representing OSHA please identify themselves for the record?
Robin Maples, OSH Standards Specialist with the Kentucky Labor Cabinet.
Good morning, Mr. Chairman, members of the committee. My name is Chuck Stribling. I'm the Federal State Coordinator for the Labor Cabinet.
Thank you so much. We have
Dale, are you on there as well?
I'm on here, yes, but I'm workers' claims.
We're gonna handle this OSHA reg first, and then we'll proceed to the workers' claims reg. So we have a staff amendment on the workplace standards reg. Is there a motion for approval of staff amendment? We have a motion and a second. Without objection, it is so ordered. If you could, Mr. Stribling, if you could describe what this reg is doing. I know there's been some discussion on OSHA regs, another set of regs, and I just want to make sure this is totally separate and doing something different. If you could comment on that.
Yes, sir, it is. This reg just amends the procedures that the standards board follows when they convene. This reg goes back to about 1975 and has been touched one other time, I believe, in 1982. And it has a lot of language in it that is no longer pertinent or relevant. So this amendment was in the spirit of HB 50 from 2017 to update all the regulations to bring them more in line with today's practice. It has nothing to do with any other standard that you heard about or worked with us on.
Thank you, sir. Any questions from members of the committee on this set of regs? Seeing none, thank you, sir.
Thank you.
It's already been called, so we're gonna move on to the Department of Workers' Claims. Would you please identify yourself for the record again?
Thank you, Mr. Chairman. Bob Swisher, Commissioner of the Kentucky Department of Workers' Claims.
Good morning, Mr. Chairman. Dale Hamlin, Assistant General Counsel for the department.
Thank you so much. There are staff amendments. Do we have motion for approval of the staff amendments? We have a motion. Do we have a second? We have a motion and a second. Without objection, it is so ordered. I don't have any questions personally on this. Do any members? Representative Hale has a question.
Thank you, Mr. Chairman. Excuse me, either one of you gentlemen may address this. And I'm not sure if I'm correct. You may have to correct me here. I've been wrong plenty of times before, but as I look at this, there seems to be some fairly significant changes to some of the workers' claims here. Could you just quickly give an explanation to us? I think would be a little bit helpful. Where it says establishes procedures for a program to mediate disputes regarding the entitlement to workers' compensation benefits. Could I just get a quick explanation of that? Maybe I'm looking for something that's not here, but.
Yes, sir, Representative Hale. This mediation program is actually in this regulations promulgated pursuant to statutory directive of KRS 342-276. What we're doing here is to create a formal process by which parties to litigated workers' compensation claims can ask that their claims be referred to mediation for the opportunity of a quick negotiated resolution. So once a claim's been filed and assigned to an administrative law judge, the parties believe at some point during the proceeding that they would like to have the matter referred to a mediator to see if they can resolve and actually come to a settlement quicker than they would in the normal resolution of the litigated claim. This creates that opportunity and procedure for that to happen. So it's basically an adjunct or an enhancement to the existing claims litigation process.
May I follow up, Mr. Chairman? Just one.
You may, yes.
So basically, is it just to speed the process up somewhat?
It can be in those claims in which the parties think that they can, if they have the assistance of a mediator, actually come to a settlement agreement, as opposed to taking the matter all the way through the end of a litigated claims process. And they've got the ability now to ask the presiding judge to refer them to a mediator to see if they can negotiate a resolution of the claim.
Thank you, sir, very much.
Yes, sir.
I have a follow-up to Co-Chair Hale's question, just for clarification. To me, this seems really, really important, a really big deal. So just to be clear, it's your understanding that this change comes, this is the will of the legislature, and this comes within the purview of the KRS that you cited And this is not a change that the cabinet has initiated on its own.
You're correct, Mr. Chairman. This is a direct result of the directive in KRS 342-276. That statute actually has been on the book for a while, is that the commissioner create and establish a mediation program. And looking at that, we decided that it was certainly time to do that. In a sense, this has been happening kind of behind the scenes informally. Our chief administrative law judge has served as a mediator for the past couple of years with a 90+% settlement rate. So we thought that we should take the next step, comply with the statutory mandate, and formalize the process to give more people the opportunity to participate in the mediation program.
Thank you so much.
Yes, sir.
Any other questions from members of the committee? Seeing none, please call the next regulation. Thank you, sir.
Public Protection Cabinet, Department of Insurance, 806 KAR 9360 with a staff suggested amendment.
806 KR 9360 amends to make technical amendments, require pharmacy benefit managers to provide a listing of clients, which shall include any non-ERISA, self-funded, or governmental plan, and a listing of any delegated or contracted companies that perform part of the pharmacy benefit management services, and update material incorporated by reference. The staff suggested amendment amends various sections for clarity and to comply with KRS Chapter 13A, including to update the pharmacy benefit manager license application.
Would representatives of the Department of Insurance present themselves for the record?
Yes, good morning. I'm DJ Wasson. I am the Deputy Commissioner at the Department of Insurance.
Thank you. There's a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. We have a second. Without objection, it is so ordered. Any questions from members? I have a quick question. Are these regs a result of, I think it was SB 5 a few years ago?
That's correct. This was a result of SB 5. We had an initial application, and now that it's been in effect a few years, there are just some clarifications and that needed to be made so we get those applications in cleanly. So these are the technical amendments to do that.
Thank you so much.
Thank you.
Any questions? Seeing none, please call the next regulation. Thank you.
Energy and Environment Cabinet, Public Service Commission, 807 KAR 5056 with staff suggested amendment.
807 5056 amends provisions for automatic fuel adjustment clauses used by electric utilities to recover increases in fuel costs, subject to consideration by the Public Service Commission to delete a provision that applied to contracts after December 1st, 2019, and required the Commission to evaluate the reasonableness of fuel costs in contracts and competing bids based on the cost of the fuel less any coal severance tax. The staff suggested amendment amends Section 1 to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Yes, my name is Jeb Penny. I'm the Acting General Counsel for the Public Service Commission. I'm appearing alone.
Okay. We have a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second. Without objection, it is so ordered. We're going to actually spend a little time here and dig down a little deeper on this one. And this, in my notes, this is something that you don't usually want to see, where it says this provision is part of ongoing litigation. So I'll start us out and just describe to us basically what the reg does, and then describe. Is ongoing litigation, does that mean a rate case, or what does that mean?
It was a case challenging the constitutionality of Section 3 Sub 5, brought in the Eastern District for the United States courts here in Frankfurt under Title 1983. It was brought by a coal company based out of Illinois. And their claim is that because of removing the severance taxes of any jurisdiction, it violated the Dormant Commerce Clause by interfering with interstate commerce. because certain states do not have severance taxes, Illinois being one of them that does not have it.
Okay, so I'm trying to get my head wrapped around that. So this, how did we treat this coal severance tax before?
We had not addressed, we meaning the commission, I apologize.
Sure,
I guess
yeah.
The commission had not addressed the coal severance tax at all when looking at the cost of fuel. If you would allow me to take a step back, in a nutshell,
Sure, please.
What the fuel adjustment clause does, it allows a generator, electricity generator, of which there are, I think, 5 in Kentucky. So you have LG&E and KU, Kentucky Power, Duke Energy, East Kentucky Power, and Big Rivers. They all purchase fuel to fuel their plants. And so rather than every few years they come in for a rate case to recover the cost of fuel, the fuel adjustment clause allows them to, on a monthly basis, to recover the cost of fuel. If the fuel is above a certain amount, then they can be recovered as a credit or as a charge on the customer's bill. But if it's below a certain amount, then it's a credit on the customer's bill. The commission has historically just looked at it as maybe a holistic approach, not just the cost of fuel, cost of transportation. In 2019, the commission, in response to a joint resolution from the legislature, undertook to amend many of the provisions of the fuel adjustment clause, but one of which was to address a request from the legislature just to, incent the burning of Kentucky coal over others. And so initially, the commission proposed to promulgate a reg that would only remove the cost of the Kentucky severance tax when looking at the reasonableness of fuel costs for the Kentucky generators. However, after a public comment period, several of the generators, East Kentucky Power, Duke, Kentucky, all raised concerns about the constitutionality of the provision, and at which point the commission amended the proposed regulation to remove all severance taxes from all jurisdictions. The regulation was to apply to fuel contracts entered into after December 1st, 2019. Shortly in November of 2019, Foresight Coal sent a letter to the commission threatening to sue the commission in federal court if they did not suspend the regulation. The commission then sought a legal opinion from the Attorney General's office as to the constitutionality of the fuel adjustment clause. Now, the Attorney General's office did conclude that the fuel adjustment clause was constitutional, and the commission went forward with enforcing the regulation. However, in March, or even before March of 2020, Foresight filed their suit against the commission. The commission engaged the offices of the Attorney General for its representation, and the commission did prevail against a motion for a temporary injunction in United States District Court. However, as the commission went forward with responding to discovery, it became evident to the commission it might be best if the commission were to seek a settlement on this issue. The reason being is that under 1983, if a litigant is successful against the state, they can recover attorney's fees as well as real damages. And rather than get into a long, drawn-out jury trial, the commission concluded that it would be better to seek settlement. And part of the settlement, where Foresight would walk away, would be to remove this clause from the fuel adjustment clause.
So it's amazing how sometimes we have a paragraph dealing with a technical change to a reg, but there's a long backstory to that change, and this is one of those cases. So when this reg goes into effect, basically, when considering fuel adjustment charges, all the severance taxes will be baked into the cake. Is that kind of the way this would proceed?
You mean if this is accepted, if this
Correct.
Paragraph
Yes.
is removed? Yes, it would just be part of the cost of fuel at which the commission would look. Prior to this amendment, taking the amendment that is in effect right now, the commission didn't look at the cost of severance tax in the overall cost, and neither did the utilities track that. They just responded to requests for proposals, and the commission would review those overall for reasonableness, not just price, but how good the supply was, how frequently it could get there, were there be any interruptions in transportation.
So the PSC still held some authority. They were allowed movement on this.
Yes, the commission's always had a great deal of I guess, plenary authority to review the fuel costs.
Okay, so it's kind of putting us back to where we were prior to the joint resolution.
Yes, Chairman, that's what it would do, save for some of the other amendments we made prior to that, but that are not concerning the issue here.
Thank you so much. Sorry it took me a while to get my head wrapped around that one. Do we have any other questions from members of the committee on this set of regs? Seeing none, please call the next regulation. Thank you.
Thank you.
Public Protection Cabinet Horse Racing Commission, 810 KAR 2020, 810 KAR 4010 with an agency amendment 4030, and 810 KAR 8060.
These regulations update requirements relating to racing, general procedures, entry, subscriptions and declarations, and post-race sampling and testing procedures. The agency amendment for 810-4010 amends Section 3 to permit verification by a successor to the Thoroughbred Racing Protective Bureau.
Would members of the Horse Racing Commission please identify themselves for the record?
Hello, this is Jennifer Wolsing. I'm the General Counsel for the Kentucky Horse Racing Commission.
Good afternoon, Chairman. I'm Mark Guilfoyle, Executive Director, Kentucky Horse Racing Commission.
Good morning, Chairman. I'm Dr. Bruce Howard. I'm the Equine Medical Director for the Kentucky Horse Racing Commission.
Thank you so much. If it makes members of the Horse Racing Commission feel any better, Representative Hellringer's not here today. That was a joke. I'm glad to see some people laughing. Any questions from members of the committee on this set of regulations? We do have before we start, we do have an agency amendment. Is there any discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? We have a motion and a second. Without objection, it is so ordered. Any questions from members on this set of regs? Wow. Seeing none. Thank you, guys. I appreciate it. Please call the next regulation.
Department of Housing, Buildings, and Construction, 815 KAR 20-150. This also has an agency amendment.
815-2150 amends the provisions for inspections and testing related to plumbing requirements to establish remote inspection provisions due to the coronavirus pandemic and add material incorporated by reference. Staff suggested amendments were approved by this subcommittee at the January 13th meeting to amend Section 3 to comply with the drafting requirements of KRS Chapter 13A and to clarify due process procedures. The agency amendment amends Section 3 to disallow still photography for virtual inspections, clarify that medical gas installations and installations that require multiple visits from inspectors are examples of work that is too complex for virtual inspection, clarify that inspections in areas of inconsistent or unreliable cellular or internet connectivity, poor video quality, and technical issues that would prevent clear inspection are examples of situations that are not feasible or practical for virtual inspection, and clarify that underground plumbing installations that require more than one inspection and final installations on new construction are examples of situations that would not provide adequate inspection if done virtually.
Thank you. Would members of the agency please identify themselves for the record?
Yes, good morning. Benjamin Siegel, General Counsel for the department, and I'm joined by the department's Commissioner, Rick Rand, and the Director of Division of Plumbing, David Moore.
Welcome, Commissioner Rand. I think you know how this thing works, don't you?
I do. Thank you, Mr. Chair.
we have an agency amendment. Do we have a motion for approval of the agency amendment? We have a motion and a second. Without objection, it is so ordered. I'm going to let the department maybe I know Representative Frazier, do you have questions on this?
I just wanted to make a comment.
Okay. Let's go ahead and do that. Go ahead.
This was on our agenda, and I appreciate you working with me in the interim to make some very necessary changes, and so I'm appreciative of that, and I think it's to a place where it just needs to be implemented, and then it can be tweaked, as we say, or further modification can be made as necessary. But I appreciate the background and the reasoning on this, and for working with me on some much-needed changes that I think will improve the reg. Thank you.
We also have with us, actually in the LRC complex, we have Brian Tharp. If you would identify yourself for the record and why you're here.
Brian Tharp with the Kentucky Association of Master Contractors.
Okay. According to my sheet, it says you're here to speak in favor.
Yes.
Of the regulations. Okay. Do we have any other questions from members of the committee? Or anything that the agency would like to add or anything? Seeing none. Yes, sir. Please go ahead.
Chairman, I just want to just quickly add, speaking for the department also, thank you to Representative Frazier for working with us, especially during a busy session. That we appreciate her with that.
Thank you so much. Oh, Representative Hale.
Thank you, Mr. Chairman. I want to just say, Commissioner Rand, it's good to see you again, sir.
Good to see you, my friend.
My seatmate. But it's good to see you again. We had a nice phone conversation a few days ago about this, and I want to just thank you all for working with Representative Frazier. She had some concerns and questions previously about this, and as long as Representative Frazier is good, this is kind of out of my purview, but if she's fine with this, then I'm fine with this. So, but thank you all for working with her and meeting those concerns. I really appreciate that very much. Thank you all. And it's good to see you again, Commissioner.
Yeah, and if I may say, Mr. Chair, it's good to see Representative Hale back. He was my seatmate, and so I'm glad to our conversation last week. I didn't know that he had been ill, but I'm glad to see him back. And we all know that's the way this process works. And working with Representative Frazier, she was excellent to work with and made some really good suggestions, and I think really improved our regulation.
Thank you. Any other questions or comments? Please call the next regulation. Thank you.
Cabinet for Health and Family Services, Office of the Secretary, 900 KAR 11011. This does not have additional amendments.
This regulation repeals 900 KAR 11010 medical review panels because the authorizing statutes were repealed in 2019 and all pending claims have been resolved.
Would the representatives from CHFS identify themselves for the record?
Hello, my name is Donna Little. I'm the Deputy Executive Director for the Office of Legislative and Regulatory Affairs. And I'm the only representative for this regulation.
Thank you. I was waiting. Sarah was on my sheet, but apparently she's not here. That's fine. We have no amendments on this set of regs. Do we have any questions for Mrs. Little? Seeing none, please call the next regulation. Thank you.
Department for Public Health, 902 KAR 10010 and 110. Neither of these have additional amendments, and all of the following regs have additional amendments: 131, 140, 150, 160, and 170.
902 KR 1010 amends to update authorizing statutes and definitions, delete provisions for an earth pit type privy, add prohibition against installing an on-site sewage system if a publicly or privately owned sewage treatment works is available. 902 KR 10110 amends to incorporate an application for a permit to construct or alter an on-site sewage disposal system, add a $50 fee for on-site sewage disposal permit that was previously $30, add required fee established by the local Board of Health, add a plan review process, including the $60 fee required for an on-site sewage disposal cluster plan review that's the same fee as required previously, and make KRS Chapter 13A changes. 902 KR 10-131 repeals regulations because these provisions have been included in other regulations. 902 KR 10-140 amends to update terms, establish advanced and master level certifications, update application for certification process, add an application fee, add installer certification level standards, and add a $25 test registration fee payable to the local health department, and that individuals passing the exam shall submit to the cabinet a $45 certification fee, which was increased by $20 from the previous fee. 902 KR 10-150 amends to add defined terms, update the application process, clarify that a farm that disposes of less than 2,000 gallons of its own domestic septage each year shall be registered with the local health department, but does not need to be permitted by the local health department, and revise the inspection fee schedule. 902 KR 10-160 amends to update definitions, incorporate applications for site evaluation and permit to operate a disposal site, update storage capacity requirements, update treatment requirements, clarify a permit must be renewed annually, require signage to be posted at the disposal site, and remove disposal restrictions and provisions for sites that existed prior to the effective date of the regulation. 902 KR 10-170 amends to establish an application process and fees for a business license to service or maintain septic tanks and other various tanks, pits, and devices, establish an application process for each vehicle used for hauling, establish a surety bond amount, update storage facility capacity limits, update administrative enforcement procedures, and incorporate the application form. The staff amendments for 902 KR 10-140, 150, 160, and 170 all amend various sections to conform with KRS Chapter 13A. Additionally, the staff amendment for 902 KR 10-131 amends to add cross-references.
Would the members from the Department of Public Health identify themselves for the record?
Yeah, good morning. This is Julie Brooks, Regulations Coordinator for the Department for Public Health.
Are you alone?
No, I have Angela Billings with me.
Sorry, computer issues. Good morning. This is Angela Billings. I'm a section supervisor with Department for Public Health Environmental Management Branch.
Thank you. There are staff amendments. Do we have motion or approval of the staff amendments? We have a motion. We have a second. Without objection is so ordered. I'll start out. Do any other members have any questions on this set of regs? This seems to be a lot of changes. If you could just give us really, I know this may be difficult to do, but could you just really give us some highlights on why these changes? And I know there are some fee increases. So why the need for this? And just give us two or three of the highlights on what you're trying to accomplish.
Sure, I'll go ahead and start. So most of the regulations that are being amended have not been updated since the 90s. So a lot, even though sounds like a lot of changes, a lot of them are just to bring the regulations into the current KRS Chapter 13A compliance. Angela, will you speak to some of the provisions that are changing?
Yes. In reference to 902 KAR 10-010, the public restrooms, that primarily is for our local health departments. That reg allows them to go into various buildings and facilities and inspect the public restrooms that they do not have an active permit for. In essence, health departments get a complaint on a restroom in the courthouse. It's not a facility the health department regulates, but yet they can go in and investigate and ensure that that is a restroom that's kept, current. So there are no fees associated with that one. let's see, I'm trying to go down the line. I apologize.
It's okay.
902 KAR 10110, the on-site sewage disposal system permits, that has not been updated since, and correct me if I'm wrong, Julie, since 1990, I
It was
believe.
1992.
Thank you, Julie. So the local health departments are actually working on the same permit fee from 92 and doing more work in that instance. Continuing on down to 902 KAR 10140, the installer certification program standards. I want to put a plug in for Kentucky. We actually are one of the best states nationwide for our certified septic system installer program. Many states are modeling their program after ours. So we can really be proud that we are not at the bottom. We are one of the top 5 across the nation in our program. And that just gets us a little more into offering different levels of masters for the installers, and kind of gives them a little bit more pride in what level that they can perform at. So we're really happy with that one. And continuing on to 902 KAR 10150, that one references disposal sites. We have actively 63 permitted disposal sites in Kentucky, so we don't have a lot, but this actually brings it into where it is more, it is a better, well-explained approval process to get those land application sites approved. And that also goes into the 902 KAR 10160, which is how those disposal sites are actually operated. It improves the inspection process on that. And again, that goes into the next one, 902 KAR 10170, the septic tank servicing, which handles septic system pumpers. And those pumpers also pump grease traps as well. So it helps bring those more into a little bit more, not necessarily with permitting, but better with the inspection process, and the health departments can deal a little bit more with those septic tank pumpers.
I've got a question on a KR 10150. So what was the reasoning for, if a farm has 2,000 gallons of domestic septage, what's the reasoning behind registering the farm?
Okay, they have, the way the reg currently reads before our proposal to improve it, the farmer could actually spread up to 2,000 gallons of his own septage. With this new reading, in the past, it did not put a caveat on if the neighboring farmer could bring his septic tank sewage and spread it as well. With this new reading, it limits that 2,000 gallons to just that one farmer, the ownership, that it's only his septage. If he brings in anybody else's, then he does need to actually obtain a permit. With his own septage, he does not have to obtain a permit with the local health department, just that he needs to register to the health department. I'm going to be spraying some of my own sewage on my own property.
Thank you. Any questions for members? Seeing none, thank you so much. Please call the next regulation.
Department for Health, Office of Inspector General, 902 KAR 10160 and emergency, and 902 KAR 440 and emergency. Both of these have staff suggested amendments.
902 KR 2160 amends to add licensure requirements for both inpatient and outpatient services to be reimbursable by Medicaid. Add the American Osteopathic Board of Neurology and Psychiatry to the certification option for a behavioral health professional. Add list of professions that may supervise a peer support specialist. Add targeted case manager definition. Allow a facility director to be a certified psychologist with autonomous functioning. Add diagnostic criteria for withdrawal management services. Allow various services to be provided face-to-face or via telehealth. Delete that crisis intervention is required to be provided on site. Require peer support to be developed through a person-centered planning process. Require intensive outpatient program services to be 6 hours per week for adolescents. Require outpatient group and family outpatient not to exceed 3 hours per day unless medically necessary. List requirements for service planning, including face-to-face meeting with the client. Delete previous requirements for case managers and make technical corrections. The amended after comments version clarifies that a chemical dependency treatment center can provide ASAM levels of care 3.7 and 4.0 services consistent with their license if appropriate and are required to comply with ASAM service criteria. Clarifies that a CDTF may provide clinically managed high-intensity residential services. Adds telehealth as an available method of delivery consistent with the requirements in 907 KR 1580 and adds ambulatory withdrawal management services as an outpatient service. The staff amendment amends various sections to comply with KRS Chapter 13A.
902-2440 is being amended to clarify that a psychiatrist may be certified or eligible to apply for certification, allow a crisis stabilization unit to serve 16 clients rather than 12 clients who require overnight stays, add a definition for licensed clinical alcohol and drug counselor, update the definition of peer support specialist to include a registered alcohol and drug peer support specialist, and allow for peer support specialists to work under the supervision of a licensed clinical alcohol and drug counselor. Delete the prohibition against co-locating a residential alcohol and other drug treatment entity and a residential crisis stabilization program on the same campus. Add language to allow the executive director to serve in a dual role as the executive director of a residential crisis stabilization unit and an AODE if both facilities are owned by the same entity and meet other criteria. Add language to allow the program director to serve in a dual role as the program director of a residential crisis stabilization unit and an AODE if both facilities are owned by the same entity and meet other criteria. Remove language allowing residential crisis stabilization units to use the Kentucky National Background Check Program to satisfy the state-level criminal record check requirements. Add a cross-reference related to services provided by residential crisis stabilization units. Allow a licensed clinical alcohol and drug counselor to provide screening, assessment, treatment planning, individual therapy, group therapy, and family therapy. Add a cross-reference pertaining to residential crisis stabilization units that provide treatment for acute withdrawal, and add licensed AODE programs as a program for which residential crisis stabilization units may have a linkage to help promote continuity of care after discharge. The staff suggested amendments amend Section 1 to comply with the drafting requirements of KRS Chapter 13A.
Would the representatives of the Office of Inspector General identify themselves for the record?
Yeah, thank you, Mr. Chairman. Adam Mather, Inspector General, and I've got Kara Daniel with me, Deputy Inspector General.
Thank you. We have a staff amendment. Is there a motion for approval of the staff amendments? There is a motion and a second. Without objection, it is so ordered. Do we have any questions? I have no questions. Do we have any questions from other members? Representative Frazier.
I'm surprised you didn't ask this. I was just curious why the first one, it has an emergency regulation.
Yeah, I think I'm having trouble hearing you, but I think you asked why this should be considered an emergency regulation. Is that
She
correct?
did. That's correct.
That's correct.
Okay, thank you. Sorry. So this is a companion regulation or companion regulations with Medicaid in order for them to fund these ASIM levels of care. So under KRS 13A, it was cited under both subsection 1, 2, and 4 in order to confront the serious and imminent danger posed to Kentucky citizens by the exacerbation of the opioid epidemic during COVID-19 pandemic. And this could, for subsection 2, this could inhibit without making these changes, it would inhibit funding from federal funding to the Medicaid office. And then it protects human health by increasing access for treatment of substance use disorder in the state of Kentucky.
Great. Thank you very much.
You're welcome.
Any other questions? Seeing none, please call the next regulation. Thank you.
Continuing under Office of Inspector General, we have Food and Cosmetics 902 KAR 45160 and 902 KAR 45190. 190 has a staff suggested amendment.
902-45160 amends food and cosmetic packaging, processing, storage, and distribution operations to add requirements for cosmetic manufacturing facilities, update citations, and update material incorporated by reference. 902-45190 establishes permitting, packaging, and labeling requirements for CBD food and cosmetic products and products that include CBD as a food additive. The amended after comments version makes technical corrections, adds a definition for approved source and hemp, clarifies labeling provisions, and clarifies requirements for ingestible products. The staff suggested amendment adds 2 definitions, clarifies 1 definition, and amends Section 3 to delete a redundant labeling font requirement.
Thank you. Would the Department of Health identify themselves for the record?
Yeah, this is Jubilee Brooks, Regulation Coordinator for the Department for Public Health, and I'm the only one speaking for these regulations today.
Welcome back.
Thank you.
There's a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, is so ordered. Any questions on these 2 regs? Representative Hale.
Just probably a comment on this. On the 902-045-160 reg there on the food cosmetics. I know there have been some issues concerning or relating to some of the fees on this particular regulation in the past. I guess my question is this reg doesn't appear to affect those fees in any way, does it?
No, sir, it does not.
Okay, that was my only question. Thank you.
Any other? Thank you, Co-Chair Hale. Any other questions from members? Seeing none, please call the next regulation. Thank you.
Department for Medicaid Services 907 KAR 15070 in emergency and 080 in emergency, both with staff suggested amendments.
907-15070 is being amended to require a plan of care for each recipient, add withdrawal management and medication-assisted treatment to services required to be offered, require a 24-hour professionally directed evaluation, observation, medical monitoring, and addiction treatment for withdrawal management, remove a list of individuals who may provide treatment because approved behavioral health practitioner is included, permit a screening to be provided face-to-face or via telehealth as appropriate, require assessment to use ASAM, delete recovery and add restoration of a recipient to their best possible functional level, require peer support services to be limited to 30 hours per week of direct recipient contact and no more than 8 recipients in a group, require withdrawal management services to meet ASAM criteria, require medication-assisted treatment to be an available treatment option, require facilities to have appropriate ASAM level of care certification by July 2021, and make technical changes. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
907 KR 1580 amends to add inpatient treatment center services, change face-to-face to direct contact, expand definition of approved substance use disorder treatment provider, require treatment centers to have accreditation within 1 year of initial enrollment unless a one-time 90-day extension is granted, permit various services to be face-to-face or by telehealth as appropriate, require medication-assisted treatment to be provided by an authorized prescribing provider, require an inpatient chemical dependency treatment program and medically monitored inpatient withdrawal management services to meet ASM criteria, and require documentation of how services are provided via face-to-face or telehealth. The amended after comments version includes telehealth services as an alternative, requires collateral outpatient therapy not to exceed 3 hours per day alone or in combination with any other outpatient therapy per recipient unless additional time is medically necessary, specifies use of the most current version of the ASAM criteria, clarifies authority of physician assistants, includes federal authority for waiving or expanding buprenorphine prescribing authority, requires an inpatient chemical dependency treatment program to be provided face-to-face if being provided as a ASAM 3.7 level of care or by face-to-face or telehealth to be provided at a 3.5 level, requires an inpatient chemical dependency treatment program to include clinically managed high-intensity residential services and adds requirements for those services, adds requirements for ASAM 3.5 and 3.7 level of care services in the same facility, adds an exception for a physical structure requirement in which inpatient chemical dependency treatment services is provided, adds an exception allowing a facility to not be limited to 16 beds if the facility possesses residential certification as well, moves the year a one-time provisional certification expires from 2021 to 2022, and requires a chemical dependency treatment facility to possess an appropriate ASAM level of care certification by 2022 and not 2021. The staff amendment amends various sections to comply with KRS Chapter 13A.
Would the members of the cabinet identify themselves for the record?
Good morning. This is Veronica Cecil, Senior Deputy Commissioner for the Kentucky Department of Medicaid Services, and I will let Ms. Hoffman and Mr. Scott introduce themselves.
Good morning. This is Leslie Hoffman, the Chief Behavioral Health Officer for the Department for Medicaid Services.
Good morning. I'm Jonathan Scott. I'm Regulatory and Legislative Advisor for DMS.
Thank you so much. I think the legislature needs a Chief Behavioral Officer. Just a little joke there, trying to liven it up a little bit. We have staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, it is so ordered. That was a lot there, but what we do understand that it does relate to the opioid crisis and having our regs comply and work with federal regs and guidelines and Medicaid. So, do we have any members on the committee have any questions on these sets of regs? Seeing none, please call the next set of regulations. Thank you.
Department for Behavioral Health, Developmental and Intellectual Disabilities, 908 KAR 2270. This has an agency amendment.
908 KAR 2270 establishes Community Behavioral Health Training Program and the awarding of training grants. The agency amendment amends sections 2 and 3 to delete language that repeated statutory provisions and to correct a web link.
Would the agency identify themselves for the record?
My name is Justin Derringer, Regulation Coordinator for the department.
My name is Michelle Blevins. I'm an Assistant Director in the Division of Behavioral Health.
Thank you. We have an agency amendment. Is there any discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment?
So whatever. I was waiting for Representative Martin.
Representative Marzine refuses to make the motion, so Co-Chair Hale has made the motion. Do we have a second? We have a second. Without objection, it is so ordered. Any questions on these regs before us? Seeing none, please call the next regulation. Thank you.
Thank you.
Under Department for Community-Based Services, the SNAP program, 921 KAR 3010 and 3045. And under daycare, 922 KAR 2120, 230, 240, and 250. None of these have additional amendments.
921-3010 is being amended to reflect Federal Agricultural Improvement Act of 2018 changes in the definition of the term expungement, shortening the SNAP EBT fund's inactivity time frame from 12 months to 9 months. Replace the term alien with immigrant when referring to sponsored immigrants, consistent with guidance from the Department of Homeland Security, the Immigration and Nationality Act, and the U.S. Citizenship and Immigration Services Systematic Alien Verification for Entitlements Sponsorship Initiative, and make other technical corrections necessary for compliance with KRS Chapter 13A. 921-3045 is being amended to decrease the period of time for which a SNAP EBT card may remain inactive before SNAP benefits are expunged in accordance with the Federal Agricultural Improvement Act of 2018, require a notice of expungement action to be sent at least 30 days in advance, and require expungement if the agency verifies that all household members are deceased. 922-2120 is being amended to add requirements for nutrition, physical activity, screen time, and sugary drinks in accordance with 2020 Senate Bill 45. 922-2230 is being amended to allow eligibility credit hour requirements for the director's credential to be obtained at an accredited institution of higher education outside Kentucky, and make technical updates to comply with the formatting requirements of KRS Chapter 13A. 922-2240 is being amended to address asynchronous learning, synchronous learning, online trainings or webinars, and independent studies, prohibit the repetition of online training courses to meet the required training hours with certain exceptions, include requirements for becoming a cabinet-approved training agency, update citations, update material incorporated by reference, and make technical changes to comply with KRS Chapter 13A. 922-2250 is being amended to make a correction in the planned program instruction required for the Commonwealth Child Care Credential, and make technical updates to comply with the formatting requirements of KRS Chapter 13A.
Thank you. Would members of the department identify themselves for the record?
Good morning. My name is Laura Beacon. I'm the Regulation Coordinator for the Department for Community-Based Services, and I have someone joining me to answer any child care related questions as well, if she will introduce herself.
My name is Dr. Sarah Vanover, and I'm the Director for the Division of Child Care.
Thank you so much. There are no amendments. I'll start us out with a quick couple of questions here. I know we're attempting to align ourselves with the Agricultural Improvement Act 2018. If you could, on 3010 and 3045, just give us maybe a more in-depth version of what we're actually doing here with these SNAP benefits.
Sure, no problem. It actually is pretty simple. It's a change that is needed for compliance with federal law.
Could you do us a favor?
Yes,
Do you have?
course.
Could you up your volume a little bit?
Yeah,
if you don't
sorry
mind?
about that.
It's okay.
Thanks for letting me know. Yes, so just let me know if you can't hear me clearly, but these changes in these SNAP administrative regulations are just needed for compliance with federal laws. Currently, for the SNAP program, if SNAP benefits are not used any period of time during 12 months, those benefits start to roll off the card due to inactivity. Per federal law, that has changed from 12 months to 9 months. So if SNAP benefits are not used for 9 months consecutively, those benefits start to roll off 1 month at a time. And again, we are required to notify recipients of that coming up as well with at least 30 days notice.
Okay.
Mr. Chair, I just have a quick question.
Yes, Senator, please proceed.
Thank you. And this may be outside of our local purview, but one of the reasons they become inactive so often, it would be homelessness, or they lose that. My younger brother ran a homeless shelter here at Salvation Army Center of Hope. And so sometimes when a family would lose, I guess, an address, or they would be couch surfing or whatever, fall off the map.
Senator,
how quickly would they be able to get those back going?
Did the department understand the question? Senator, you were cutting out there for a little bit, so I'm trying to make sure.
I apologize. I know I've been had trouble all day. I've been cutting in and out.
That's okay. That's okay. Did the department? Did you understand the senator's question?
Yes, I believe so.
Okay.
So, if I think if the senator said that if the benefits weren't used, how could that be corrected? Could they get those back on?
In the event they lose them, how quickly can they get that back up and running if they were able to get housing again?
Well, housing is not required for them to maintain this. Now, if they've changed residence or are homeless, they may not have received the notification of upcoming expungement of benefits, but they would be able to use those benefits even if they were homeless or if their residence changed. Anyone can, and again, it's 1 month at a time. So they would have to have inactive status for, it was 12 months, now it's 9 months, and then for each additional month after that expungement starts. So this is quite a long period of time that we're talking that these funds would have to be inactive. And if someone does lose all of their benefits, they can apply or reapply at any time.
Thank you.
You're welcome. I got a question about 3010. It changes the word, replaces the term alien with immigrant. And this is my lack of knowledge. So are these benefits, this describes how the benefits are available to immigrants. How are illegal immigrants treated in under this section?
Illegal immigrants cannot receive benefits, only if they're being sponsored, and the administrative regulations contain specific requirements for an immigrant to receive any benefits. There are specific criteria that have to be met, and they have to be sponsored.
Any other members have questions for the representatives? Seeing none, thank you so much. We appreciate it.
Thank you.
That is the end of the agenda.
I believe we end up in session, and then our next meeting would be back to our regular second Tuesday of the month, which would be April the 13th at 1.
April the 13th at 1 is our next scheduled meeting. Do we have any members with questions to come before the committee? Once again, I thank everyone for their service and their attendance today. I know it was a little different getting over here, but we appreciate that. And if there is no further business to come before the committee, do I have a motion for adjournment? Thank you.